I'm going to talk about probably one of my most asked for topics when I do in-service training for teachers. Student discipline, when I first started in, about December of '98 practicing school law at TSBA, the presentation on student discipline looked a lot different than it does today. But over the years, it seems that technology moves faster than the law. And sometimes you as educators are faced with dealing with issues related to technology that maybe the law doesn't really address specifically. So you have to struggle with looking at what's going on in the classroom and on the street sometimes and with kids in their technological devices, and does the law even address it? Now, but what I've come to find out or think about is the more things change, the more they stay the same. Now, I don't think I can use the clip because I don't think the sound will work. But does anyone remember the movie Mean Girls? Came out about 10 years ago. I use a lot of clips from Mean Girls because even 10 years ago, that movie is still relevant today when we're talking about bullying, and I do a lot of training on bullying and the law regarding bullying. But also, my favorite clip when I'm thinking about technology and are the issues you're facing really that different is the clip, remember the slam book? This was a scene from the movie where the Mean Girls collected a slam book, and it was a physical book where they wrote mean things about different students and sometimes teachers, and one of the teachers in the movie, and they kept it. Well, somebody made copies of the slam book, one of the girls did, and just papered the walls of the high school with a slam book. And the clip I usually show just shows the mayhem that ensues when everyone sees copies. What's different today? Today, there's an app and a website kids use that's an electronic slam book. Now, it's the same concept. It's mean girls or mean boys being mean, but boy, they can get the message out a whole lot faster, and they can hurt a whole lot more feelings. But I think what we have to remember is kids have always gotten in trouble. They've always done stupid things. Sometimes the tools and instruments they use to do the stupid and mean things are different, but the basic concepts of student discipline and the rules that we have to apply when we're disciplining students are kind of the same. Now, we do have to look to the court system and when laws change and see how to apply a set of facts the law to a certain set of facts, but the concepts are the same. And we're going to talk about a little bit how to deal with them. I think first you have to understand the sources of your authority to discipline. So I'm going to go really quickly through the basic discipline rules and just where school districts get their authority to take action against the student, whether it's something that they do in the classroom, kick another student, throw a spit wad, or if it's something more harmful like a electronic slam book that goes out, or a hit list. Several years ago, that was all the rage with kids. The sources of law, we've got federal and state law. Of course, we've got the court cases that we need to look at. We've got the State Board of Education rules. And really important is your local board policy, because the Tennessee General Assembly has given school districts very broad discretion with regard to disciplining students for any behaviors that become disruptive to the educational environment. Now, so you have to have good defensible policies, however, and you have to have consistent and equitable application of those policies. Now, I always like to put this slide up. And by the way, I'm going to give you my email address now before I forget. It's christy.ballard@tn.gov. I don't give handouts, but if you shoot me an email and say you want a copy of this presentation, I'll attach it and send it back, and you'll have a full electronic copy. So don't feel like you need to take a bunch of notes and write what's up on the screen, because I'll give you a copy of this. How many of you have had parents come to the school district and almost quote things that they've seen on an episode of Law & Order? I think nowadays we've got a lot of parents who've watched too much Law & Order. Remind students and parents and attorneys sometimes that school officials, you make school decisions. You make school disciplinary decisions. You don't make criminal decisions. I had a parent call me once and said, the principal pulled my son off the football field during football practice after school and brought him into his office and questioned him about an incident. I said, okay. And she said, and he didn't even read him his rights. I said, well, ma'am, that's something that law enforcement officers must do during a custodial interrogation. That's when a person's freedom is at risk. It does not apply in the school setting. And I tried to be very serious, and she argued a minute, and I laughed, and I said, ma'am, I think you've watched too much Law & Order. I tried to make light. That was a mistake. It did not go over well. And she did hang up on me. But I think that a lot of people forget that, and schools do have a lot of authority. Not that students do not have rights, and we're going to talk about some of those, but schools have broad discretion, as they have to. Now, what authority do they have that I'm talking about? There are some statutes in Title 49, Chapter 6, 4012 through 4017, and together they basically say school boards have to have a discipline code. The code shall contain the behavior expected and the consequences of the failure to obey. This is just letting everybody know that schools can have their own discipline codes, but they have to let parents and kids know what the rules are. It says codes shall be posted at each school and referenced in student handbooks and given to school counselors, teachers, administrative staff, and parents. Basically, that's why at the beginning of every school year you give out that student handbook, so that parents are aware of the behaviors, that if those students engage in those behaviors, here are the consequences. And that's part of due process, which we'll talk about. Every school district needs to look at their policies and determine if they've included all the policies that are required by law. Sometimes when I do a longer presentation, I talk about the art of policy writing. I'm not saying you have to have a lawyer write your policies, but it's always good to have your board attorney review those policies, because sometimes just a little tweaking of the wording can make a huge difference. For example, if you write a policy that says alcohol possession on school grounds is a violation, blah, blah, blah. Do you think that covers everything that you intend to cover? What if you add possession? What if you add consumption? Does that cover everything? What if Johnny gets liquored up at home and then shows up at the football field? He's not consumed it on school grounds. He's not possessed it on school grounds, but he's intoxicated. So language is important, and you definitely, because now everybody gets a lawyer and comes to the school when they're punished. So it's important to make sure you've covered everything. Now, policies are hard, though, because you can't have a laundry list that lists everything that you're going to punish Johnny for. You have to be specific enough so that Johnny understands and has notice of the types of behaviors he will be punished for. But you can't cover everything, because the minute you have a list, guess what's going to happen? Kids are going to do something that's not on the list. Make sure they're reviewed often and changed, and by all means, you have to review it after every legislative session, because we never know what they're going to change, and you have to update your policy to be in compliance with the law. And you can have policies that are different school to school, or you can have a district-wide policy. Anyway, policies are important. Here are the ones that are legally required regarding discipline. You have to have a corporal punishment policy in Tennessee. Get a lot of calls from people, and there are organizations that are very against corporal punishment. Some school districts have banned corporal punishment. How many of you are in a school district where you still administer corporal punishment? Several. How many of you know for sure that your school district has banned it? Okay. Bottom line is you have to have a policy and procedures if you're going to implement it, how it's to be implemented. Not going to talk about the pros and cons and whether it works and the philosophy of corporal punishment, but as a lawyer you can probably imagine what my opinion is about corporal punishment and the risk involved. Hazing. You have to have a hazing policy. That's been on the books for a lot of years, probably longer than I've been in this job. Bullying and harassment. There's always been harassment and discrimination policies, and back 4 or 5 years ago, for the first time, they actually put bullying language in the law. And I think Tennessee was probably ahead of the curve for most of the country in actually specifically putting bullying language and a requirement for a bullying policy in state law before a lot of other states did. We tweaked that through the years from time to time, and there was a bill pending before the General Assembly this session. I think we know bullying is a problem. It's always been a problem. Even when I was in school, I remember bullying being an issue. I think it's one of the toughest things schools deal with. You can have a perfect policy. You can do everything right. You can train everybody, the teachers. You can train the students. and you can still have an issue. And it can be very damaging. We hear stories on the news, kids commit suicide over bullying, but it's really hard to deal with. What I don't think is helpful anymore is continuing to tweak our state law and our policy on bullying. Not that I think it's a bad thing to have a law and a policy, but what I told the House Education Committee during this past legislative session is you can have a perfect law. For us to stop bullying, it's going to have to take more than just writing new policies. It's going to take a community effort, everyone working together. We've got to teach kids that it's cooler to be a friend than a mean girl, basically. We've got to get that point across. Laws are not going to solve the problem alone. All right. Now, this is the statute. If you want to read the discipline statute, Tennessee, read 49-6-3401. This has been on the books forever. It basically authorizes principals, principal teachers, and assistant principals to discipline students. And it has a list. Now, it doesn't mean it's an exhaustive laundry list of these are the things you can do. It's basically saying these are the types of behaviors that you can punish students for. And I'm going to give you some examples. It also gives you the due process requirements, what process is due to a student before you can deprive them of their right of attending school through either suspension or expulsion. It talks about the type of written notification you must provide parents before you remove their student from the regular classroom. It very specifically talks about if you expel a student for more than 10 days, you owe them more formal due process, and that's when you have those student discipline hearings. This is all in this one statute. Now, I just want to note that when I'm talking right this morning, I'm talking about general ed discipline. We all know that if you're dealing with a child receiving special education services, there are some additional hoops that you must jump through. So I don't mean to leave those out, but we could do another day on that. So, on special ed discipline. Okay, here's part of that list, and I've kind of paraphrased some of them. Willful violation of the rules. So, I mean, it's pretty open. It gives, like what I said earlier, schools have a lot of discretion. Immoral conduct, vulgar language, violence or threatened violence, willful damage to property, inciting others to do any of these things. That's pretty broad. Defacing school property. Possession of a firearm. Now, this isn't what we call our zero tolerance language. This has always been there. It's later on in the statute, and we'll talk about that. Possession of a knife. Verbal assault on personnel. This is not the aggravated assault that school system officials or school officials that is in the zero tolerance language. Drugs. And here are a couple newer ones that were added a couple years ago. 2 or more students initiating an attack on a student at school or school activity, including travel to and from school. It kind of sounds weird. When the bill was originally filed, the intent was to add this to the list of the 3 things requiring a mandatory calendar year expulsion, which we call zero tolerance. But it was trying to get at gang violence, and I think administrators and school board attorneys quickly said, now, that's really, number one, we already have policies on the books dealing with fights that would incorporate any gang activity as well. And this looks really hard to implement. What does that actually mean? So instead of just pulling the bill, they just added it, oh, well, you can. Well, you already could. School boards could already have a policy on this. Also, bomb threats, including a false report. A lot of school districts still do, and in the past, there was a year or two when there was one school district that just had a bomb threat every week. And those are really hard things to deal with. It's almost like calling off school for snow. You're in trouble if you call off. If you don't, you're in trouble. You can know in your heart what kid's doing it, that it's not a serious threat. But if any parent in your community finds out there's a bomb threat and you didn't evacuate the building, what's going to happen, Dan? It's not going to be good. So it's a serious issue, but I think the General Assembly kind of looked at it as, we want to save the zero tolerance offenses to the most serious things. Schools can make anything they want a zero tolerance offense at the local level, but they took it out of the zero tolerance section and just added it to this list of things that you could punish for, which was unnecessary because of this one statement. This is the favorite one. This is what you star and underline. Any other conduct prejudicial to good order. Once the General Assembly added that sentence, they don't ever need to file another bill about giving school districts the authority to handle student misconduct or disruptions to the educational environment. They've already given you all the authority that you need. But every year we usually see a bill about something related to discipline. And this last one I think is really interesting, and it's the one that directors probably struggle with the most. Now, what it says in the law is off-campus criminal behavior for which a student would be charged with a felony, and their continued presence on campus is a disruption. What I say is and it's pretty well settled law in the courts, any off-campus behavior where you can show a logical nexus between that off-campus behavior and some sort of real material disruption to the educational environment, you can punish for. Now, if you can't show that connection, you can't always punish for it. For example, and when I first started, it was things like cheerleader got in a fight with another cheerleader at the Tasty Freeze after the ball game on Friday night because they wanted to date the quarterback of the football team. They were mad at each other. One knifed the other, big brawl at the Tasty Freeze. People went to jail. Could you punish those students? Could you suspend them on Monday morning? Possibly yes. And these are always fact-specific questions, but I mean, there could be issues of retribution, people being afraid. Anything that you can show a disruption, you could. On the other hand, if you had a kid working the Special K or 7-Eleven, Quick Stop on the weekends, he's working there for months. And over the course of those several months, he's embezzled thousands of dollars. He gets caught. It's obviously a felony, very serious crime. Gets off on a technicality. He's out on bail. Either way, he's going to be showing up at your school on Monday morning. Can you suspend him for that? Can you show that logical nexus between that behavior and school disruption? Now, you might not want him to work the concession stand at basketball games, but you're probably not going to suspend him. Those are obvious issues. It gets trickier when you're dealing with maybe a drug deal going down in the parking lot of Walmart. Maybe you can show that they actually took up money and did a lot of wheeling and dealing on campus. You can show some connection. Bottom line is you have to show that connection. And sometimes kids do really obnoxious things and awful things where you can't show that disruption and you can't always punish them. Years ago, it was easy. Those are the kind of cases. Now what you're dealing with is electronic misbehavior, because what's the issue about Facebook and Twitter and all the social media, and every kid has a computer at home now and they have their own website. All that happens off campus. So now when you're looking at these types of issues, you're not just looking at on-campus behavior where we know it's very clear that the Tennessee General Assembly and the court system has given you very clear and broad discretion to take action. Now it's unclear. And this is when I say kind of technology, the law hasn't caught up with it. We're still looking for the courts to give us further guidance on how to take these issues and apply the law. Okay, I'm gonna skip through these because we don't have a lot of time. That statute tells you the terms of suspension. I want to get to zero tolerance. All right, zero tolerance. You know, I talked about there are 3 places in 49.6.3401 that require a mandatory calendar year expulsion that can only be modified on a case-by-case basis by the director of schools. Those things are, the history of that is Congress basically passed a law, the Gun-Free Schools Act back in 95, that pretty much said, or 94, it pretty much said states, if you want to continue to receive federal funds, you all have to have a policy in place that requires mandatory calendar year expulsion, just like I said, for students possessing a firearm on school grounds. It was limited to firearm. There is a definition of firearm in the Gun-Free Schools Act. It's a long, complicated definition. Anything capable of expelling a projectile through means of explosives. It covers ammunition and silencers, all that gun stuff. So that's what Tennessee did. 96, the General Assembly came around and added to that and added unlawful possession of drugs. Now, unlawful possession of drugs. We've tweaked that definition through the years. It talks about legend drugs and controlled substances, which are clearly defined terms in the Tennessee Code and the Criminal Code. What it basically means is anything you have to have a prescription to possess, and it covers all your street drugs and things as well. It does, early on there was some question, does it cover marijuana? Yes, it does. It does not cover tobacco. There's separate laws for that. It does not cover alcohol. And it's unlawful possession. So if Johnny comes to school with his Ritalin that is prescribed to him, has he committed a zero-tolerance offense? No. He might have violated another school rule, such as you have to check your over-the-counter and your prescription medications in with a school nurse. Might have violated that, but he's not committed a zero-tolerance offense. Also, across the country, when this law first passed in all states, you saw a lot of cases about, a girl gets zero tolerance for bringing ibuprofen in her pocketbook. Over-the-counter medications that you're not in unlawful possession of cannot be a zero-tolerance offense. Here again, they might be a violation of another school rule. It's not a zero-tolerance offense. Now, the whole third grade may have to go to the emergency room because they've all taken, No-Dos, White Crosses, those caffeine pills that truck stops have. They're dangerous, and they can hurt little kids. They're not good for you. But it's not a zero-tolerance offense because kids aren't going to be in unlawful possession of them. Early on, the law was battery of school system employee. There is no longer, that was when the criminal code used the phrase battery. The criminal code was revamped several years ago, and we just now, a couple years ago, I think maybe it was last year, it all starts running together when you do this a while, we recognized there was no definition in the criminal code for battery, so you had to go use the old civil or common law definition of battery, which was harmful or unpermitted touching. So I could go over and smack you on the arm, and technically I've battered you. And we thought, that's really not what the General Assembly intended for kicking a kid out of school for a calendar year. So we tried to align it with what the clear intent was. In the criminal code now, they don't use battery, they use assault, aggravated assault, especially aggravated assault. So the General Assembly changed that language to aggravated assault, which basically means assault using a weapon or entailing serious bodily injury. So for an offense against a teacher or school resource officer, as the language says, to be a mandatory calendar year, it needs to be aggravated assault. And that's not of students. Now, that's covered elsewhere in your policy. For this language, it's school officials. Like I said, it's a calendar year. Superintendents or directors can modify on a case-by-case basis. They have to be very careful about doing that, applying the rules consistently and treating people the same. And they have to be able to clearly articulate the reason behind why they're modifying a punishment. And that's why I said earlier that schools can add their own zero-tolerance offenses, and most all of them add other weapons. I really support adding other weapons because when you have a weapon on a school campus, what's it generally? It's not going to be a gun generally. What's it going to be? Some kind of blade. And so I think it's really important to add that language. And I haven't seen a school discipline code that didn't add other weapons, but it's like I said earlier, policy drafting is key. Do you just want to say knife? Well, then you've got the kindergartner with the butter knife in her lunchbox, and the director's got to modify every time something like that happens. No, you want to use maybe the criminal code definition of weapon so it's very clear that you're talking about a weapon. That's where you get those cases where you see in other states where the girl got suspended because they had chains and she had a Tweety Bird keychain and it was considered a chain. Well, that's just stupid. You've got to define things clearly so you don't end up with nonsense like that. All right, we have a Tennessee School Security Act. There is still a law on the books that says basically schools can punish kids and prohibit pagers. Possession of pagers, there are kids now who don't know what a pager is. Back when this law was passed, who had pagers at school? Drug dealers. It was prima facie evidence of drug dealing. There's also a law about you can prohibit people wearing gang clothing. What is gang clothing? You can't define it. You basically have to have something in your policy that pretty much says, hey, if something becomes identified with a gang, we're going to prohibit it. Because it changes all the time. It's whatever they want to be, and you can't define it. But here again, anything disruptive. We know that cell phones are the new thing. There is, and I'll talk about it if I get time, there is an AG opinion that pretty much says, yes, schools can have policies prohibiting or limiting the use of cell phones and on school grounds because they can be a disruption. It's not just about pagers or specific things. That's why it's not good for the General Assembly to pass laws, because in 2014 we have a law in the books about pagers. The same way when Pokemon cards or Beanie Babies were big, we didn't need a law about schools can get rid of Beanie Babies. It'd still be on the books, and that'd be silly. All right. Everyone knows what due process means. Your school law class taught you due process clause, no person shall be deprived of life, liberty, and property without due process of law. Students have due process rights. And you know, students actually have a property interest in attending school in Tennessee. And so anytime you're going to deprive them of that right through either expulsion or suspension, you have to give them due process. Now there's procedural due process, substantive due process, and procedural. Substantive means, does the punishment fit the crime? Is it reasonable? If you have a policy that says if you chew gum off with your head, that's not reasonable. That's going to be a substantive due process issue before the courts. Then you have procedural due process. That means notice and opportunity. Some type of notice that, hey, if you engage in this behavior, you're going to get punished, or you're in trouble now because this is what you did, and some type of opportunity to be heard. Now, every offense a student is punished for, they're owed due process. Every one. So it may be Johnny threw a spit wad at the teacher. Johnny goes to the principal's office. Principal says, "What'd you do, Johnny?" "Well, I didn't do it. Sally did it." Or, "I was mad at her, I did it." Okay, a day of in-school suspension. Boom. Johnny's had his due process. He's had his notice and has had his opportunity to be heard. What we know from this law and from some cases, Supreme Court cases anyway, if it's a serious offense that's going to require more than 10 days out of school or out of the regular placement, that student is owed more formal due process, and that's when that SDHA, student disciplinary hearing, comes into play. Now, that's the groundwork. Now let's talk a little bit about the e-behavior, or the e-misbehavior that I like to call it. Okay. I thought this was an interesting fact I found from a story online. Children spend an average of 7.5 hours per day on their communication gadgets. 7.5 hours. I probably do the same thing myself. I mean, I can't lie. Here are the topics. And these are heavy-duty legal issues that come into play when you're dealing with Twitter and Facebook and Tumblr and Instagram and whatever new thing. When I start looking at this kind of stuff and trying to keep up with what they're doing, I feel really old. Freedom of speech, First Amendment issues we're going to discuss. Whether or not, like we said earlier, it's on campus or off campus. Search, Fourth Amendment issues. When you take up a phone, can you search it? Can you look at the pics on it? Can you look at the text messages? Under what circumstances? Potential criminal acts. And when do you have to call the police? When you have Johnny's iPhone and you find something inappropriate on it, do you call the police? Do you call the Department of Children's Services? What obligations do you have there? Bullying and harassment. Cyberbullying. There have always been bullies. But when Johnny has a Twitter account with 1,000 followers, think of how many people he can get his mean tweets out to in a matter of seconds. So it's not that there are probably more bullies. I don't know. Maybe there are more bullies. I don't know that that's the case. I just know that it's a lot easier to bully kids with an electronic device. All right, let's talk about the free speech issues. Now, when you are in school, in your school law class, and you were talking about student speech and the rights students have under the First Amendment to the U.S. Constitution in the school setting, there were some big cases that everybody studied. Everybody studied Tinker versus Des Moines, right? Vietnam War, the students that put the black armbands, protesting the war. They were punished for it. It wasn't a popular opinion at the time. Went all the way to the U.S. Supreme Court, and the issue was, do students have the same First Amendment rights in the school setting as an adult would on Broadway? And what the court ended up saying is, students don't shed their constitutional rights at the courthouse, at the schoolhouse gates. We've got several cases that talk about that. But those rights they're not the same as my right standing here or your right out on Broadway. And what this case taught us is if there is speech that poses a substantial disruption, I've heard that a lot this morning, schools can punish for that speech. Now, you can't practice viewpoint discrimination, and you have to really be able to show a disruption. There has to be a reasonable forecast of a disruption, maybe issues you've had in the past, things like that. Well, so this is one case we look at, but this was an easy one because it happened on campus. Now, did I go back? I went backwards, sorry. The other big seminal case from 1986, Bethel versus Frazier. Remember this case? This was where the student gave a speech at a school assembly nominating a fellow student for school council. It was very vulgar and lewd, used a lot of sexual innuendo. And the student was punished. The issue was, did that violate that student's First Amendment right to be lewd and vulgar? Court said, you know what? This is a school setting. Students' rights, they do have First Amendment rights, but they can be censored somewhat. Building on the Tinker versus Des Moines substantial disruption, now Bethel told us lewd and vulgar speech, schools can also curb that and punish for that in the school setting. Here again, in the school setting. Then we had Hazelwood versus Kohlmeyer. This was a student newspaper. The issue here, I think the students were writing stories about divorce and single parenthood maybe. Anyway, there were topics that the administration was a little bit uncomfortable with at the time. This was a case from 1988. And they took the stories out of the school newspaper. Court upheld the punishments. Why? The holding was, in this case, this was school-sponsored speech. Not only is it on campus, it really smacks of school sponsoring. It's a school newspaper. Schools have discretion with restricting that type of speech. More recent case from 2007, Morse versus Frederick. Now this was weird. This was not on campus, but it was clearly kind of a school-sponsored school event. It was students in Alaska. The case came out of Alaska, and they were holding up signs watching the Olympic runners carry the torch across some part of Alaska. And the sign said, "Bong hits for Jesus." You all remember that. It got a lot of media headlines. What was the issue about bong hits for Jesus? What were the students? They were promoting illegal drug activity. And that's what the court said here. School officials may punish students for expression that promotes illegal drug use. This case was a little more interesting because, there was a little debate about whether or not it was on or off campus, but I think the court kind of settled with, there was enough of a connection with a school-sponsored event that it could be treated like on-campus speech. There was another case, it's not specifically a school case from 1969 that I always like to throw in because it's about threats. And I think we all know that in any setting, a true threat can never be protected speech. So when you have a student, even if they're threatening another student, obviously that's going to be a disruption to the educational environment. True threats aren't generally protected, so we add that one in. Here's the problem with cyber speech. We have all these great cases that seem very clear, and all the student speech cases that came after cite all these cases. They analyze, okay, they're going to analyze it under Tinker about substantial disruption. Or they're going to say, oh, well, this is lewd, this is Bethel. We're going to analyze it under the Bethel test. But you really can't use those cases as much when it's clearly off campus. Because now we're seeing courts grappling with the issue of, do students have more protections for their speech when it doesn't happen on school grounds, at a school event, and there's no connection to the school environment? And here's where we don't have any really clear legal guidance. The cases, all the different circuits, they're kind of everywhere. There was an opportunity for a couple cases to go before the U.S. Supreme Court, and we were all kind of waiting with bated breath, all the lawyers, about we're finally going to get some clear guidance from the U.S. Supreme Court on student speech that's off campus, and they denied cert on the cases. So we're kind of still wondering. Here's what we do know. And I've already talked about how easy it is for on-campus and off-campus, why it's hard. Let me talk about a few cases. Layshock versus Hermitage School District. This kind of gives you an example of how the courts are kind of all over the place. And these are some earlier ones where it's not clear if they're really analyzing it being on or off campus. This was one, and it's old because it's talking about MySpace, and we all know MySpace is over. The student created a parody of his principal on MySpace on his grandmother's computer away from school. He was suspended for 10 days, and in this case, the court applied the Tinker standard. They clearly said that there's no nexus between the speech and the school environment and any disruption, they actually looked at it and ruled that Fraser's standard, which is the lewd or vulgar speech, didn't apply to off-campus speech. So that's one case that tells us kids can be pretty vulgar as long as it's not disruptive, and the school can't do a lot. There's some other cases. There's a JS versus Bethlehem case. These are 3 Pennsylvania decisions that I think were kind of interesting, and they were heard at about the same time. This one is a student created a website at home, which they often do. It contained derogatory comments. It was about an algebra teacher, and it compared the algebra teacher to Hitler. And he actually put that he was trying to raise money to hire a hitman to kill the teacher. Now, what the court pretty much said is the student was expelled. The court said, the speech was basically not disruptive, because it's not like everybody knew he didn't really intend, or it wasn't a true threat, I'm sorry, because he didn't really intend to kill the teacher. It's not like he set up a PayPal account or anything. But it was disruptive. So the court determined that the school couldn't punish under Fraser for lewd and vulgar, but they hung their hat on Tinker. When you have something like that about a teacher, it's disturbing, and it could disrupt the educational environment. The thing about a lot of these cases is a lot of them really don't spend a lot of time talking about the difference between on and off campus. And that's what we need now from the courts. We need some clear guidance on that. This Killian case, also out of Pennsylvania, student created a website at home that contained a derogatory top 10 list about the school's athletic director. The student emailed the list to his fellow students. I think this case is different. I would argue this case, it found its way to campus. Once speech like this finds its way to campus, then you can consider it on campus. Then you've got them. Then you have a lot more discretion. So for example, a kid creates something at home, but they access it on their school computer, or like the slam book from Mean Girls, they bring it to school, or they're all passing it around on campus, even through they're texting it around during school hours. I think that you can no longer look at it as off campus. You can look at it as on campus, and you have more discretion. But a lot of these cases aren't that clear. I want to get to my favorite. Well, let's talk about some Sixth Circuit cases. We don't have any clear guidance yet in the Sixth Circuit. The Sixth Circuit hasn't very clearly spelled out off-campus conduct like some of the other districts have. We only have district court cases. This is an older one from 2002. This was a kid who was suspended for creating and accessing a school website that labeled pics of students as losers, kind of a bullying type thing. The court implied it was on campus and found no disruption. But the court also stated that punishing pursuant to policy for inappropriate conduct is vague. What does that tell us? Be careful how you draft your policies. Make sure that, words like inappropriate, that's very vague. That's not a great word to use in your policy. It's like when I review contracts for the department, I want to beat my head against the wall when I see people put things like meaningful in a contract. Well, what does that mean? And I always circle it and say, what's that mean? Or high quality. What does that mean? According to who? So be careful about words like that in your policy. And in the Sixth Circuit in this case, they made a stand that it's on campus. So it really didn't give us a whole lot of guidance. The Mahaffey case, he was suspended for contributing to a website that discussed hating and killing fellow students. But the website was kind of written in a joking manner. It was clear that it was not serious, although it was obnoxious. It was considered off campus. There was no true threat because it was obviously written in a joking manner. The court applied the substantial disruption test but found no disruption. So the student actually prevailed on their First Amendment claim. So we've got that case out there, and that's one you want to look at carefully. Tipton County, Tennessee, there's a case. This was kind of interesting. The kid made a fake MySpace page for an assistant principal containing his pic, bio, and suggestive comments about female students. We all know that could be, if people think that's real, that could be horribly damaging to an educator, because by the time you investigate and you realize it's not actually true, a whole lot of damage can be done to an educator's reputation. So in this case, the court didn't even discuss, and see, the earlier cases, they didn't really clearly talk about off campus versus on, but the court did uphold the suspension because people could believe it was authentic, and it was one of those things. It wasn't as clearly a parody as some other websites. Now, this is the one that just kind of blows my mind. This is a Seventh Circuit case. This was a case about a bunch of girls during the summer at a slumber party. Their Facebook pages, they were set to private. Not everybody could see them. And it's TV versus Smith Green Community School Corporation in Austin Couch. It's a federal judge in Indiana ruled the school can't punish students for posting provocative images of themselves online at slumber parties. Now, they weren't wearing school uniforms or anything. I think they were members of the volleyball team. And if you read the facts of this case, they're terrible. I mean, the pictures and the things that these girls were doing, rather than suing, their parents should have been mortified, ashamed, and I'll just say, if I'd done that when I was in school, I probably wouldn't be here today if my daddy had seen it. But that's not what happens now, we know. Parents don't react that way like they used to. And in this case, I love this quote from the court in the opinion. Not much good takes place at slumber parties for high school kids, and this case proves this point. They were holding lollipops, they were posing lewdly in it, and the court used the word raunchy pics and stripper style. I mean, it's an interesting opinion when you read it. But and here's the scary thing. They weren't suspended from school. When it came down to it, the only punishment, they had an honor code for athletics. And it was something that you all probably have heard, anything that brings dishonor to yourself or to your team. They ended up having to set out a couple of volleyball games. That was it. And what I always say is you have no property interest in being a cheerleader, being on the football team, or playing volleyball, so you don't need due process when we take away those kinds of privileges. But guess what? This court said that this school district, by making them set out volleyball games for this, violated their rights to free speech. So what we know is students in the Seventh Circuit right now have free speech rights when it's off campus that are pretty hefty, even if the speech is disgusting, vulgar, lewd. It's kind of, it's shocking, but it's there. The court also basically said that those honor codes are vague. So I would really caution, but who knows what the Sixth Circuit would do, but when you have a court ruling this way, you have to listen. It's not binding on the Sixth Circuit or in Tennessee, which is in the Sixth Circuit, but a lot of these outside cases, courts can consider highly persuasive. So it's something to look at. And like I said, the judge found that the policy that disciplines for bringing dishonor or discredit upon school or student is vague and overbroad. So basically, your kids have a whole lot of, in some circuits, have a whole lot of rights to be gross and obnoxious, as long as, the court here found that there was no disruption. There was no true threat. It was just gross. So, what do we know for sure? Like Oprah, this is what I know for sure in her magazine. There is a solid legal argument that off-campus expression can, in certain cases, be punished if the Tinker test is met. So, like we said earlier, even if it's a fight at the Tasty Freeze or something that happens on Facebook, if you can show a true disruption, like under the Tinker standard, you can probably punish the students, even though they have First Amendment rights. Before you punish off-campus speech, make sure there is that logical nexus. And it can't be, you can't just think, oh, there'll probably be a disruption. You need to be able to really forecast a disruption. It's the same way, the standard where students, remember the whole world of T-shirt law, that's what we used to talk about before Facebook and Twitter, is T-shirt law, and what could kids wear on a T-shirt to school. Sometimes I miss those days. What is disruptive? If a kid wears a Confederate flag to school, or a Malcolm X T-shirt, or, I Dream of Jeannie, whatever, when can you banish that type of picture from the school grounds? When you can reasonably forecast a substantial disruption. And the way you do that is, we've had issues in the past. A lot of school districts have had to ban Confederate flag t-shirts because they've had racial tensions, they've had fights, they've had really big issues in the past, and that's how they justify banning something that normally could be protected speech. So you really have to be able to prove something. All right, we don't have a whole lot of time. Cyberbullying is just bullying using electronic devices. We all know that. We all know that when you're dealing with all these issues on Facebook and Twitter, that it could trigger your bullying policy because cyberbullying is listed in the law. So, but here again, you have to show that the definition of bullying is met, even when you're dealing with off-campus conduct. Sexting, I want to quickly hit sexting because, like we said earlier, some things when you're investigating, it could trigger you to call law enforcement. Everybody knows what sexting is now. It's the one thing, I always say kids have always done stupid things. We did stupid things when we were kids. This is the one thing I can't wrap my brain around. Why kids do this. Good kids do this. And I've seen some statistics about the number of kids in the school setting who have actually texted a partially nude or nude pic of themselves to another person. It's astounding. My best friend Sarah, we talked about it one time. She always asks me what my presentation. She's a pharmacist. And I said, I don't get that. Why are kids, and I don't have kids, so maybe that's part of the reason. She said, well, Christy, by the time we took the picture and we blew on it and shook it and looked at it, we would have come to our senses. Maybe that's why kids do stupid things. It's so instant. They can do something and post it online in 2 seconds. They never have time to think about the consequences. Anyway, if you're a teacher and you find a kid with a nude pic or something like that on their phone, what's the first thing you need to do? Get it to an administrator. Administrators need to get it to the central office. These are the kind of things you need to look at it and make sure that it doesn't trigger your obligation, one, to call DCS. Is there an issue? Is there maybe something to do with a minor involved with an adult? Law enforcement, I always think that you should bring law enforcement in. And when it happens is usually not the time to have the first conversation about these issues. I think you should early on have a good relationship, invite law enforcement out, offer them some square pizza, have a little meeting about, we know we're going to deal with these things and we want to follow the law because the definition of possession of child pornography is pretty broad, and no school official wants to ever be, accused of distributing or possessing child pornography. So at times we've dealt with things like this at the state special schools. We have a really good relationship like at TSD with the Knoxville Police Department. Now, not that we want them to handle it as a law enforcement action and arrest the kid. We just want to make sure that we're handling it appropriately under the law. We're definitely going to call parents in and deal with it as a school decision, but keeping law enforcement involved. Because when you have nude pictures of a minor, there's some other obligations that you have under the law. Here's what I think are my list of rules when you discover sexting. Tell the parents of all the students involved. I think it's very critical to do that. Determine if a report of suspected abuse or neglect or a violation of criminal law, child pornography, has taken place. This is one you want to get your board attorney involved in, probably, if you haven't handled something very similar recently and already gotten advice on it. Minimize the risk of child pornography charges. That's what we're talking about. Take proper disciplinary action. Follow your anti-bullying and harassment policies. What does this mean? So, a young girl texts a nude pic of herself to her boyfriend. You know how young love, it's all wonderful until it goes south. And that's how a lot of the sexting starts. Boy, girl, sext a nude pic of themselves to the boyfriend or girlfriend. They break up. What does the person do? Sends it to all their friends, and they send it to their friends. And then the next thing you know, the whole student body has a picture. And you could go from that situation of a bad breakup to what? Bullying, harassment. What's the wrong thing to do? Just punish the girl who sent the pic, right? You could end up with a Title IX issue. You've got to punish everybody involved, not just one side, because they've all violated the rules if they've forwarded those things. So be careful about that so you don't trigger other policies. And I've listed, if you get a copy of this, the mandatory reporting of suspected child abuse statute and the child pornography statutes, just if you want to get a peek of what the language actually says. The child porn statutes prohibit possession and distribution of material that includes a minor engaged in sexual activity or simulated sexual activity that is patently offensive. The definition of sexual activity is fairly broad and not easily understood. So that's why I'm saying that be careful and don't think that you have to make that call, get law enforcement involved. And years ago, people said I was being overly cautious, but I called law enforcement in and had them look at something because it looked like a situation, and they said, no, we're not going to take action. We said, we're going to handle it. I just want to document that I brought you in, and they looked at it and let us kind of take it from there. So I think that's always safer to do. In other states, there are some cases, and further in the presentation I don't have time for today, where principals were actually charged with failure to report child abuse and possession of child pornography. There was just to make it clear how important it is to bring the parents in early. What happened is, in this one case, there was a kid who had a nude pic on his phone, or partially, I don't know if it's totally, and they thought, we're not sure about it. They kind of dealt with it. They talked to the kid, and they went on. And then a little while later, he got in trouble for something else. And they finally called the parents in, and in talking to them about the current punishment, they said, oh, by the way, he had a partially nude pic on his phone a couple weeks ago. And the parents were furious, as anybody would be if you found out the school knew your child had something like that on their phone and they didn't tell you. They were furious. So guess who called the police and reported the principals? The parent. That's how they got charged. And I think part of the problem is, in that case, the principal or assistant principal forwarded it to the principal and said, here's, you need to save it. Guess what? When you forward a nude pic of a child, even if it's for a legitimate purpose, don't do that. Take it, protect the chain of, of command and authority, hold on to it, don't do anything else with it until you finish your investigation. Yes? Yes, take their phone, but don't. Yeah, I would be careful about forwarding emails with things like that in it. You just take possession, hold on to it. It's one of those things you don't want to show it to everybody in the building. Only the people who have a reason to take a peek at it to confirm there's an issue. I would think the director of schools needs to kind of hold on to that and kind of lead the investigation, talk to law enforcement, talk to local board attorney. Dan, how do you handle those?
Why does everything end up on my dad?
Because the bug
No,
stuff.
that's exactly what we do. We tell folks to make sure it gets to us. We get law enforcement involved as quickly as possible, not to prosecute, but
Yes.
to protect us.
Yep.
So that's an important dialogue that we have.
Okay, I know I'm probably the only thing between you and lunch. One last thing, because a lot of you are teachers, and you all have different policies on possession of phones. Now, when the laws, when everybody first started actually carrying cell phones, I remember my first one, it was the giant shoe. My parents got it for me. I got to drive it to Memphis State, keep it in the glove box. It was for emergency purposes. I really wasn't supposed to ever use it unless I was about to die or stranded on the road. It's different now. Parents want their kids to have cell phones on them. And the policies first were no phones on campus. If I see it, you're punished. That was easy. The lawyers love that because if you see it, you're punished. It doesn't matter what you're doing with it. It's hard now because after Columbine, those kids use those phones to call 911. Parents want to stay in touch. So now most of the policies allow kids to have them, but there are times when they can't use them. So now it's not just about do they have it, it's about are they using it, that word again, inappropriately. So if you're a teacher and you have a policy that allows kids to have the phones on campus and you see Johnny with the phone, can you take it up and look at it? Can you read the text? Can you look at the pics? Can you look at their Facebook page, whatever? Can you? Not necessarily. It depends on the circumstances. This is where the Fourth Amendment concerns come in. When you look at a kid's phone, that can be considered a search under the Fourth Amendment, just like the search of a backpack or a pocketbook, wallet. So, what do you have to have as a school official? Reasonable suspicion. So, if you're in testing mode and they have a phone and you suspect they're using it to cheat on the test, that's probably going to give you the reasonable suspicion to search to see if they are. Or if you think something's going on and you have reason to believe they're sexting or doing something inappropriate with the phone, then you might. But as a teacher, I would always go get an administrator and let the administrator handle it, because they're more trained to do those searches, because it does trigger First Amendment issues. We are finally starting to see some cases about searching electronic devices. And I'm sorry we didn't get to those today. I had way too much information. But email me. I'll send you the full copy. It was a pleasure being here today, and I hope you have a good school year next year.